Today, we're diving into a massive shift happening right under our noses. Seriously, the old, kind of dusty rules about who owns what are being challenged by things that, let's be honest, didn't even exist a few years back. So let's get right into it. I know, it sounds like something out of a sci fi movie, right? But this question, it's at the absolute heart of a legal storm that's brewing as we speak. It really frames the core problem we're going to unpack. Who owns an idea in a world of infinite digital copies and artificial creativity? So, welcome to the new IP battlefield. The ground here, which has been stable for decades, is suddenly shaking. You've got these powerful new technologies that are literally rewriting the rules of the game.
And look, this isn't just about big companies fighting over cartoon characters. Technology is forcing us all to rethink what it even means to own an idea, a story, or, and this is the crazy part, even your own face. Okay, our first major battlefront. This is the big one. The high-stakes conflict between these incredible generative AIs and, well, some of the most famous creative works in history. And no, that isn't a movie title. It's a real-life legal drama playing out right now. The main story here is this landmark case that's pitting the absolute giants of entertainment against a powerful new AI tool. We're talking about Disney versus Minimax. The firepower involved here is just staggering. On one side, you have the creators of Darth Vader, Superman, pretty much every character you've ever loved. And on the other side, a single AI firm whose tool, called Hailu, can spit out images of those exact characters on demand. And the stakes here are astronomical. The studios are asking for up to $150,000 for every single infringing image. Just think about how fast that number could skyrocket into the billions. This is, without a doubt, an existential fight for Hollywood. You know, a case like this is pushing the courts into totally uncharted territory. They're grappling with new ideas like algorithmic authorship. The big question is, can an AI be a co-author? Can a person and an algorithm create something together? Right now, the law has no clear answer, but this case could be the one that forces it. Okay, let's pivot from fictional characters to something way more personal, your own identity. Because in this digital age, your likeness, your digital self, has become a brand new kind of intellectual property and a brand new legal frontier. To stop and think about that for a second, your face, your voice, your name, they're all assets that can now be copied, manipulated, and totally exploited. There was a recent case with the actress Aishwarya that shows exactly how courts are starting to build a defense against this stuff. And the court's order was incredibly thorough. It blocked everything from deepfakes and fake websites to even misleading domain names. It's a really clear sign that the legal system is building a whole new toolkit, piece by piece, to help us defend our digital selves. But it's not just about these new AI threats. Even the most basic, fundamental rules of IP are being put to the test. Let's take a look at how some of the old rules are kind of starting to crumble under all this new pressure. For example, take the word wow. A popular food chain, Wow Momo, tried to stop a new company called Wow Burger from using the name, but the court said, no, you can't do that. Why? Because wow is just too generic. It's a word we all use. And unless you've spent a fortune making people connect that word only with your brand, you can't own it. It's such a critical lesson in how trademarks work. And these challenges, they go all the way to the top. There's a patent case involving a company called Link Labs that's now knocking on the door of the US Supreme Court. And it asks a question that seems super simple, but could change everything for inventors. So for a patent to be valid, the invention can't have been publicly available before you filed. But what does that actually mean today? What if a document is sitting in some digital database, maybe seen by just a couple of patent examiners? Does that count as public? Basically, the court is being asked if a confidential, unpublished patent application is the same thing as a book sitting on a library shelf. It sounds technical, I know, but if the Supreme Court says yes, it could invalidate thousands of patents overnight by completely redefining what counts as prior art. The fallout from that would be global. Okay, before we get to our final section, here's a little fun fact for you. The very first sound to ever be trademarked in India wasn't some famous jingle, it was the iconic Yahoo yodel, and that really opened the door for all sorts of other sound trademarks. All right, so we've seen the battles, we've seen the threats, and all the confusion. So for this last section, let's try to bring it all home. Let's build a concrete, actionable playbook you can use to navigate this wild new world. First things first, we have got to bust a huge myth. So many people think that once you register your trademark or your copyright, you're done. You're safe. You can just put the certificate on a shelf and forget about it. That could not be further from the truth.
The reality is, registration is just your ticket to get into the game. If you want to win, you have to constantly, consistently enforce your rights. If you don't defend your IP, you risk it becoming weak and maybe even worthless, just like the Momo brand learned when it couldn't prove its name was special enough.
So what does that actually look like in the real world? Well, for any startup that's looking to grow, it means doing a regular IP audit. That means being proactive, right? Checking trademarks and markets you want to enter, filing early to beat the squatters. But it also means planning your defense, auditing your NDAs with vendors, and this is the big one, actually setting aside a budget for enforcement so you're ready to fight when you have to.
When you boil it all down, this is what it comes to. In this new landscape, creating something amazing is only half the story. The other half, and probably the more important half now, is being ready to defend it.
So I'll just leave you with this question to chew on. Whether you're an artist, an inventor, a founder, the lines are blurring and the rules are changing fast. So in this new battlefield, you have to ask yourself, is your most valuable asset, your idea, your brand, your identity, is it truly protected?